Hey again, David Phillips, attorney. The question comes up all the time, can I file bankruptcy without my spouse? And the answer to the question is yes, that is very possible and in actuality happens very often. And that's because in Tennessee, being a non-community property state, it is possible for husband and wives to have totally separate debts where one is not obligated to pay the other's debts like in a community property state. So if you truly have debts that are only yours and are not affecting your spouse in any way, then you could file bankruptcy alone. There are issues now that do come up that you need to be aware of, and one would be the 2005 changes to the bankruptcy law, which instituted what is called the means testing requirements under the new bankruptcy rules and regulations. Means testing requires, in the event that you have a husband and wife filing bankruptcy, that the income for both parties is reported to the bankruptcy court. Of course, it would naturally go along that also the expenses would be part of the equation. But if you are thinking of filing bankruptcy by yourself, we still need to know the income that your spouse is bringing into the household, because it would be assumed that those monies that your spouse makes would also be used to take care of family obligations. So it is important to realize that even though your spouse is in no way a part of your bankruptcy, therefore wouldn't be impacted credit-wise like you would, we still need to know if your spouse is contributing to the monthly family income. That would then allow us to determine if you qualify for Chapter 7 relief. Where this really comes into play would be where you have a spouse that is a very high income earner, and maybe you yourself do not have a lot of income and feel like you need bankruptcy. But there are occasions where if the spouse's income reaches a certain level, it could disqualify you from being able to file Chapter 7. In Chapter 13, the spouse's income is also a necessary part of the information that we look at. However, again, the spouse would not be filing bankruptcy with you, but we need to know his or her contribution to the family budget each month, because in Chapter 13, the budgeting of the income versus the expenses is extremely important in really the whole basis of your Chapter 13 plan. So in short, yes, if you file bankruptcy, it does not obligate your spouse to do likewise. There would be a lot of occasions, though, where it would be advantageous for your spouse to join in the bankruptcy filing, because he or she may very well owe the debts as a co-signer with you, and then those debts would just fall into his or her lap if you were the one filing bankruptcy and got rid of those debts. It doesn't cost that much more, or hardly any really, for two to file versus one. So it's pretty much a common situation we see every day for a husband and wife to file bankruptcy together. That way you get a clean slate across the board and hopefully start back over with a fresh start and hopefully a better financial future. Hope this information has been of help. Please feel free to give our offices a call at any time. If you prefer to email me, just go to phillipsbankruptcy.com, go to the contact section, send us an email there, and we'll try to get right back with you. Thanks again for watching.